Mr. Burmeister.
Thank you, gentlemen. May it please the court, counsel. My name is Colmer, together with Ms. O'Loughlin and Mr. Striggins. I have the privilege of representing the accused, Adam Price. Thank you all for your service here as jurors. Mr. Striggins talked about this in voir dire a little bit. Short of voting, this probably is the most important constitutional duty that we have as citizens of the United States. And your service here as jurors is greatly appreciated by myself, Mr. Striggins, Ms. O'Loughlin, and Mr. Price. We appreciate the sacrifice of your time, your patience over the last few days, and your interaction with us throughout the jury selection process. You all undoubtedly understand why that process was as painstaking, uncomfortable, and interactive as it was. And it's because this is a difficult case. It's an emotional case. And the law demands that Mr. Price be awarded a fair and impartial jury of his peers. The law demands that Mr. Price be awarded a jury who understands that he is presumed to be innocent, and that that presumption carries forward unless and until the state can prove to each and every one of you, beyond a reasonable doubt, each and every element of the crimes they have charged him with. The law demands that Mr. Price be awarded a jury who takes that burden of proof seriously, who will hold the prosecution to that burden, and who will not falter on their convictions. The law demands that Mr. Price be awarded a jury who will not be ruled by emotion, who will not decide this case based on emotion, but based on the facts presented here in court. And that starts now. The purpose of these opening statements is to give you all, as the jury, as the finders of fact, an idea of what to expect, of what to look for, what themes may be present throughout this trial. Some people call opening statements a roadmap or a preview of the evidence to come. And you just heard the prosecution's roadmap, their preview of what evidence they expect you to hear throughout the coming days. Will be Mr. Cobb for the prosecution and Mr. Striggins for the defense, who argue to you what all that evidence means. The big picture comes together in closing arguments. But I will tell you the difficult part of serving on a jury starts now. Your job now is to listen closely to the evidence and to evaluate the credibility of the witnesses. This will be a long trial. At times it may be dry, boring even. At others, highly emotional, uncomfortable, and that's the nature of this case. You will hear from a variety of people with a variety of backgrounds and experiences who have some connection to this story. And it will be your job as the finders of fact to put these pieces together and decide their significance. The prosecution has told you what evidence they expect to present, who they expect to testify, and what they expect those individuals will tell you. Now, I'm not going to list for you the individuals the defense expects to call as witnesses, but I will tell you what we expect the evidence to show. The prosecution mentioned that you would hear from a pathologist who would tell you that the cause of death that he arrived at was asphyxia due to smothering. You will also hear testimony that asphyxia due to smothering is what's called a diagnosis of exclusion, meaning that you must eliminate other diagnoses before reaching that conclusion. You will hear that alternate diagnoses were not excluded, and in some cases were not even explored. You will hear also that the National Association of Medical Examiners has set in place certain standards regarding the conduct of forensic autopsy duties. Among those are independence. Independence from county attorneys or district attorneys, and independence from law enforcement. You will hear that during the course of the pathological investigation, or the autopsy, the state's pathologist, Dr. Berg, had multiple communications with members of the county attorney's office and with law enforcement, that he considers himself to be a paid consultant and takes direction from those entities. You will hear that the cause of death was undetermined until the prosecution requested a copy of the autopsy report several months after this incident at the end of September of 2021. And you will hear also multiple deficiencies with the testing that was conducted. The prosecution mentioned also that the defendant made statements to law enforcement and to clergy. That is true. But what you will not hear is an explanation as to what those statements truly mean. You will hear also about a multitude of physical evidence collected by the Bellevue Police Department. You will hear that very little of that physical evidence was tested for anything, and those that were tested yielded minimal, if any, results of evidentiary value. There are several things that are not in dispute. Adam Price and Mary Nielsen were going through a divorce. Adam Price was the sole caretaker for the children the week of May 13th or May 10th, as you heard Ms. Roudebush say. Emily and Theodore Price were found dead at 2716 Alberta Drive in Bellevue, Nebraska on May 16th, that they were fully clothed and tucked into their beds, and that at that time Adam Price was in the state of California, having spoken with multiple members of the clergy. There's more to the story than this. In voir dire, Mr. Striggins discussed with you all the scientific method and differential diagnosis, the process for finding an answer to a question that is truthful, honest, and conforms to the evidence in front of you. What is key to accurate execution of the scientific method is the elimination of bias and consistent performance of those steps. You cannot perform that process seeking to find a specific answer. The purpose of the scientific method is to find a theory to fit a fact pattern, not to find a fact pattern to fit your theory. The evidence will show that the state has chosen a fact pattern to fit their theory, that there are too many questions, too many stones left unturned. The charge here is first-degree murder, an extremely serious allegation. The margin of error must be low, and the law demands that proof beyond a reasonable doubt. The prosecution must prove to each and every one of you that Adam Price did with premeditated malice, or by administering poison or causing the same to be done, that he caused the deaths of Emily and Theodore Price in Sarpy County between May 13th and May 14th of 2021. Those are the state's allegations. And we discussed in voir dire its translation to speak the truth. Just because we have selected and seated you all as jurors in this case, that doesn't mean that that process is over. Your job now becomes to seek the truth, to be the finders of fact. As jurors, it is your job not to be ruled by emotion, but to be factual, to be logical, and to decide this case based on the merits. Again, what's presented here in court. To be fair, to be impartial, to examine the evidence with a critical eye, to decide whether the prosecution has met that burden of proof beyond a reasonable doubt, and to decide whether it is true as to each and every element of the crimes charged. At the close of evidence in this case, Mr. Striggins is going to stand in this spot and talk you through the steps the prosecution took to make their case. By that time, it will be clear that the prosecution and law enforcement has chosen a fact pattern to fit their theory. It violated the principles of the scientific method. They skipped steps in that process. They didn't rule out other options in their differential diagnosis. Mr. Striggins will stand here and tell you that the prosecution has failed to meet their burden. And he will ask that you find Mr. Price not guilty.